So we're going to take the next several weeks going into the detail of how to give a deposition or trial testimony, and the details. And and you'll see as we move along here that number one, it's a very, very valuable, high demand service. There's very, very few doctors that not only are willing, remember, most doctors do not want to go to court. They're afraid. Most doctors are afraid to go to court. So most doctors don't want to. And then if they do, they don't know how. They haven't been trained. Now, what does that mean? Well, that's called opportunity, is what that's called. When you actually know how to document, and you know how to give a deposition or trial testimony, you are gold in the personal injury arena, especially with attorneys, and especially with trial lawyer attorneys, which is the sweet spot, so to speak, of personal injury. Okay, so just keep that in mind. You know, if you really want to do a lot of personal injury, you not only want to learn the documentation and, you know, the personal injury presentation, etc., but you want to learn how to give a deposition trial testimony. Now you become an unbelievably high valuable commodity in your community, your county. I couldn't even tell you of any other doctors in my county. Now, the county I practice in wasn't that large, but I cannot even tell you of one other doctor who actually knew what he was doing testifying for personal injury. Now, they'll get called in, but that doesn't mean they know what they're doing. As an example, I just was an expert witness recently to a case. We did not even use any of the chiropractor's documentation because it was worthless. And we darn well did not want her on the stand. So, and the attorney understood why. You know, he knew, that's why he called me, not, the attorney was a female. That's why I didn't call her. So, having said that, just keep that in mind, that you're a very valuable commodity. Number one, if you know documentation. Number two, if you know how to do educational, personal injury attorney educational sales. In other words, create the referrals. And then number three, you know how to do deposition trial testimony. Now, you need to handle the medical part. We'll go into actually greater detail on all this, but you, and this is a shock when I teach chiropractors, and actually it was a shock to me and how I learned about it. And that's when I said, you know, it was such a negative experience the first time I did a deposition. I said, I will never let this happen again. And the reason it was a hugely negative experience, I, like so many doctors, thought the attorney knew what he was doing and he would walk me right through it. And that was not the case at all. And I wasn't prepared. I didn't know that he didn't know how to walk me through the case. And so, you know, I mean, it was so unbelievably bad, but it was too late. I didn't know he didn't know what he was doing until after the case was over. And that's when I said, I will never let that happen again. And that's what happens. So they have a rough idea, you know, but the detail that we're going to go into is immense. It's unbelievably specific and detailed. The attorneys don't have a clue of the details we're going to go in. And by the way, they shouldn't have a clue because they're attorneys. They're not healthcare providers. They're not physicians. So you're the doctor, you're the chiropractor that needs to be leading the way and showing the attorney the outline. Now, I always give the attorney the outline. I said, these are the questions I need you to ask me, and I need you to ask me them in this order. And you'll see why when we cover it, why that's so important, because we tell the story and it sequentially and logically builds on itself and goes into great detail the attorney doesn't even know about. He doesn't have a clue. And so that's why you cannot leave it up to the attorney. So I made the huge mistake And so I'm in the deposition, my first deposition, and the attorney's asking very generic, broad, open-ended questions. I'm like, after like 2 or 3 questions, I knew this case was in trouble. No sequence, no detail. He wasn't putting the pieces together much at all. And that's what I've come to find out, is most attorneys just know the big picture. They don't know the minutia and the details and the medical to literally stair step this thing to make it unbelievably strong. And that's why I've never lost a case in court. And I say it all the time. There's 2 reasons why I've never lost a case in court testifying on behalf of the facts of a patient's auto accident injury. Number 1, I didn't go to court if the information wasn't there. So there's a minimum standard, and I call that the 7 minimum categories that determine the strength of the case. So if you don't even have that minimum standard, I tried to talk my attorney out of, and I didn't have too much, because once I explained it to them, it made sense to them to just settle for whatever they could and move on. But if they did have it, it also made sense to them to stay strong, to go after the true injury award, what should have been given, and do it with diligence and conviction and persistence, to where actually they're okay with suing them and taking them to court. Now they don't do that unless they have a doctor that they know that can perform in court. In other words, you know the documentation and you know how to deliver it. They do not want to go to court, and they don't have like an anchor doctor that can kind of put all this information together. So that's unbelievably valuable when you do learn how to give depositions and what the formula is. It's a formula. It's a very specific formula. And so I give it to the attorney. I cover it. I go, this does, I explain how it works and why it works. And of course, once I do that, they love it. But sometimes it's just difficult getting them to see it because they think they already know it all. And what can you, the chiropractor, teach them about a deposition? A lot, because we're talking about medical, not legal. That's the difference. Legal is just the structure. The medical is connecting the dots. That's what they don't know. And that's what wins cases, connecting the dots to tell the story, to logically and sequentially put the case together. That's what wins cases and injury awards. So anyway, that's what happened, is after a very short time, he's asking generic open-ended questions. I'm like, oh my God, he's not connecting these dots at all. And I couldn't do anything. I could just answer his questions, but they were weak and pathetic. And he missed so much of what should have been covered, wasn't even covered, because he didn't even know to ask it. And that's when I said, I will never let that happen again. So yeah, I put together the whole deposition trial testimony with and you'll see all the components of it. And there's a lot of significant components that are pieced together that's what wins cases. And then typically when you do get the attorney to see it, if you can actually walk through it and go, this does this does this, that's when typically the lights go off in their eyes and go, man, this is really good. But it is harder to do that because they don't think you know much about deposition or trial testimony, believe me. So anyway, having said that, so let's go into some of the basics of what is the value of the chiropractor relative to the case, relative to the injury award. Where's the chiropractic experience fit into the injury award? So let's look at this first, okay? Do remember this, 97% of the injury award is from the doctor's documentation. There's 4 potential injury awards from the doctor's documentation. There's the medical injury award, the potential impairment injury award, the potential pain and suffering injury award, and the potential prognosis and need for future care injury award. So there's 4 potential injury awards from the doctor's documentation, not one. And then now they could get other injury awards, like they can get money for their car, fixing up their car. Okay, that doesn't have anything to do with the doctor and his documentation. But just be aware, 97% of that whole injury award is on your back. How well do you know your documentation, and how well do you know how to document it and put it together in a narrative report, deposition, or trial testimony? That's where the injury award's at. That's where the value is at. That's what creates referrals. So having said that, let's take a look at the value of the chiropractor relative to the personal injury case. So let's do this. Let's see if we can. Okay, you should be able to see that. This is a PowerPoint presentation. So you should be able to see that. Okay. Let me just double check something here real quick. Okay. So let's get back to this PowerPoint presentation. And let me see if we can get a better view on here. Let's go to. Okay. So let's walk through this, how chiropractors support personal injury attorneys, compensation, and punitive damage. So you don't have to be an attorney, but you got to be vaguely familiar with the legal structure. That's like, should you know that the injury awards there's 4 potential injury awards? Yeah. Should you know the basic formulas of how to convert the documentation into those 4 injury awards? Yeah. Do you need to know the details of law? No. So here's like a very good general outline of the role of chiropractors relative to injury awards. So we're looking at compensatory and punitive damages. So what is the personal injury definition? So it's quantifying injuries for monetary compensation. That's what you're doing. Why are you doing all these quantifications of biomarkers? That's why you're quantifying to convert it to monetary compensation. So personal injury damage is intended to compensate the injured plaintiff for what was lost due to the accident. So the 2 categories of personal injury compensation: compensation, punitive. Okay. So compensatory damages is meant to make the injured plaintiff whole again from a monetary standpoint. Compensate. Punitive, punish. Punitive, punish. Punish the defendant for egregious conduct and act as a deterrent. Okay, so that's what we're dealing with here. Compensatory damage is relatively easy to quantify. Property damage, it's easy. Medical bills, easy. Pain and suffering is harder. And remember, out of the 4 potential injury awards, pain and suffering, you'll typically do better with pain and suffering from a jury injury award verdict than a injury award software. And what's the number 1 reason for that? Emotion. Juries can sense emotion. Injury award software cannot. And it's just the human part. They'll take that into consideration. So the types of compensatory damages. So the medical treatment and care associated with the accident. So okay, so that's us, that's the chiropractor. And that's why it's so important to know good diagnostics, detailed diagnostics, biomarkers, specificity with therapeutic protocols, and response to treatment, the science of the 3 phases of healing. That's why all that's so important instead of winging it. Reimbursement for treatment already received. Estimated cost of future care. Now this becomes real important because do you know how to give an impairment rating? Do you know the diagnostics, the qualifiers, if there's an impairment rating or not? Do you know how to evaluate that? And then do you know how to convert those diagnostics into the injury award? And of course, that's the AMA guides to impairment rating. So that's the estimated cost of future medical care. So that's also why else is that important? Well, that's typically the largest injury award of the 4 injury awards. That's why. That's like my case that kind of put me on the map. They went from 0 to $110,000. She was 33 years old. The majority of her injury award was for future care, not pain and suffering or medical care costs. So that becomes really big. And do you know how to convert the prognosis and need for future care? The attorney's not going to know that. And so that's why it becomes real important. And again, when I say real important, I'm talking about how valuable that is. Again, if the attorney knew that you do all this information we taught, he'd be knocking down your door. But that's not reality. We got to deal with reality. They're in a state of unconscious incompetence. They don't know. So chiropractic supports the diagnostics, the treatment, need for future care. So income, entitled to compensation, accidents impact on salary and wages. This is why everything's kept track of. What the patient missed work, what were everything they paid for, not just medical, home care stuff, the device stuff at the pharmacy. That's what all that's. So would you have been able to make and it's the money they would have been able to make in the future, entitled compensation. So that gets to be important. So chiropractic reports. So what are we supporting with our documentation? Restrictions. Okay, just restrictions. What restrictions? Activities of daily living. The restrictions that are most important and vital to that human being. Activities of daily living. Time off work. That gets to be important. I see chiropractors will take a personal injury case and they won't even take them off work. And we talk about that separately, and then the duties under duress indexes, and that's direct quantification of ADLs. So this becomes a huge category, not only knowing when there's a permanent injury, quantifying the personal injury, converting the personal injury into an impairment, and then being able to explain why the person has pain or restrictions with ADLs relative to the 3 ranges of motion: active, passive, overpressure, and joint motion, and why, based on the science of the 3 phases of healing, why the person has pain or restrictions. That's invaluable. So now we also got permanent injury, future care. So property loss, well, this has nothing to do with the chiropractor. So they'll get money for the vehicles, clothing, other items damaged or the result of the accident. This is a very small percent for mostly relative to the injury award. Then you come over to compensatory pain and suffering. So that's the pain and discomfort suffered during the accident, pain and suffering in its immediate aftermath, any ongoing. So remember, out of the 4 major categories, the medicals, the impairment, the prognosis, pain and suffering is typically the hardest to show, but that's the old way. Now it's not. The way we do it, it's pretty straightforward, and it's not easy, but it's pretty straightforward to put together the mechanism of injury magnifiers, subjective findings, hybrid findings, objective findings, to show pain and suffering with ADLs. It's pretty straightforward. So chiropractic supports the pain questionnaire, loss enjoyment of lifetime activities, permanent injury, and future care. This is why we learn all these things and know all these things. This is what the case is going to be based on. Emotional distress or psychological impact. So now when you're talking about fear, anxiety, loss of sleep, emotional distress, now you're talking about even like behavioral testing. That helps a lot with trauma cases, behavioral psychology. When you get behavioral testing from a neuropsychologist due to trauma, that's what really helps nail this down. And then are they taking any medication or treatment for anxiety or sleep loss or fear? All of those are the categories that support the emotional distress or psychological impact. Chiropractic supports medication referral, anxiety or sleep, neuropsychological consult. That's it right there. So this is how we want to pay attention to the emotional distress component. We typically will get pain medication, anxiety medication from our pain management referral, and behavioral testing for neuropsychological consult. That's what supports that category of the injury award for that category. So loss of enjoyment of lifetime activities, hobbies, exercise, recreational activities. So how does chiropractic support that with the documentation? Was there a permanent injury, loss of enjoyment of lifetime activities? And of course, that's the pinnacle, because what's under that loss of enjoyment of lifetime activities? Remember, that's the tip of the iceberg. That's the finale. That's the impairment index finale, tip of the iceberg. What's under all of that to support it? Mechanism of injury, injury magnifiers, subject, relevant subject, hybrid, and objective evidence. So you've got all of these other categories that should be documenting that supports the pinnacle of that component. Loss of consortium. A lot of times we don't find this out. When I was in practice, I didn't find they don't want to tell you this at the beginning of the consultation. After they get comfortable, they start telling you about how it's affecting their love life, their libido, and their relationships. So this is a big deal. Injures relationship with their spouse, loss of companionship, inability to maintain a sexual relationship, the relationship between a parent and a child. These are difficult. So what's the documentation, and how do we as chiropractors support and document that? That's the neuropsychological consult. That's how the loss of consortium is documented. Types of punitive damages, how the plaintiff's action or inaction can affect a damages award. Their inaction, not going to care, that'll significantly lessen the injury award. So what are the punitive damage of the plaintiffs? So remember, the plaintiff is your patient that's suing the insurance company. Okay, so the types of punitive damages, the plaintiff's actions can affect a damages award. Defendant's conduct is deemed particularly careless. The real goal is to punish the defendant and act as a deterrent. But just be aware, sometimes they'll give a percentage of fault to the injured person, especially if they wasn't wearing a seatbelt. The big one is if they missed care. Those are big ones. Did they not take their medication? If they're, whatever was prescribed, the therapeutic protocol, did they not do it? That's a big one. Insurance companies go hard after that. Punitive damages, how the plaintiff's action or inaction affected damage award, injured person's role in causing the accident. Again, typically that's a percentage, and typically the police report will divvy that up. The police report, they gather all the information and they'll say typically who's at damage or even what percentage at damage. They're in action. And again, remember, they're in action. That's why you should always have what I call the personal injury report of findings to the patient, not just their health care report of findings. So what's their personal injury report of findings? Well, you should explain to them how their care relates to the injury award and how their care relates to potential permanency of the problem. That's called the personal injury report of findings. So how does chiropractic support probability of cause and effect relationship? So comparative negligence, these are all, now these topics are injury award topics, comparative negligence. If you're at fault even partially for an accident that caused your injuries. Chiropractic supports probability of cause and effect relationship. That's not going to be as much chiropractic as in regards to fault. Contributory negligence, if you're deemed partially to blame for the accident, and that you see that relatively common after that. Failure to mitigate damage, failure to get necessary medical treatment, and their injuries are now worse. That just happened to a case I was an expert in injury in. The patient did not get the proper physical medicine care, and they blamed the patient to some degree on not getting the physical medicine care. And it really wasn't the patient. The physician should have referred. Emergency room didn't refer him to physical medicine care. General practitioner didn't refer him to physical medicine care. And then the pain management doctor didn't refer him to physical medicine care, because we know how important physical medicine is in the science of the 3 phases of healing, especially the neurological component and the connective collagen, connective tissue component, the importance of physical medicine. They blamed a percentage of it on the patient for having a permanent injury because they didn't get physical medicine care. See, that was a smart insurance attorney. And then the role of chiropractic care. So you have all these different categories that you just want to be familiar with. What is it? Compensatory or compensatory or punitive? Compensatory is all the stuff they lost, make them whole again. Punitive, future. Okay. And so when we come to the injury award, we're typically looking at the 4 potential injury awards relative to the doctor's documentation, medicals. So that's why they gather all the medicals, the cost, and the insurance company fights it. And a good insurance company would fight it. They try to say that the MRI wasn't necessary, or the cost of the MRI was not usual, standard, and customary. See, they'll do stuff like that. That's common. And then you go to the impairment injury award. Sometimes that's one and the same as pain and suffering, depending on your state. But you go to the impairment injury award. That's why it's good to have solid documentation of permanency. That's, your bowel markers, your re-exams, and then it's based on the science of the 3 phases of healing, not the doctor's opinion. And then from there, you go to the pain and suffering. And that's why all the categories become important now. When we talk about mechanism of injury, injury magnifier, subjective, hybrid, objective, and whether it's primary evidence, secondary evidence, and multiple categories of evidence. That's what we call the horizontal vertical documentation. That's what creates a strong case with pain and suffering, because it's hard to believe somebody when they go, well, I hurt all the time. Well, it's not hard to believe them now if you got all this correlative evidence, this whole pyramid of evidence. That's what that's about with pain and suffering. And then, of course, prognosis and need for future care is typically the largest. And that's why we don't want it to be the doctor's opinion. Remember, we want to do everything we can for none of this to be your opinion. Why? Because it can be challenged. And for a chiropractor, it's going to be challenged. So remember, you got a 67% negative name recognition. So you want nothing in your opinion. You want it all based on third-party facts. And then you're connecting all the dots. So same with prognosis and need for future care. You don't want your opinion in there. So you're going to start with the patient's bowel markers at MMI. Well, what therapy did they need because of the bowel marker, the subjective, hybrid, and objective bowel markers? Well, what therapeutic protocol did they need at MMI because of substantiated bowel markers? So that gives you the therapy, and then the typical frequency of the therapy typically is a direct reflection of how their treatment schedule and how they've responded. Did they need more frequency, less frequency? Well, their frequency of care is a factor of how they're responding to care also. So again, it's based on care, not the doctor's opinion. And then you got the therapeutic protocol on the supported by the mile markers. You got the frequency of care supported on the patient's response to treatment. Then you go, okay, what's the cost of those therapeutic protocols? That's straightforward. Okay. The last piece of the puzzle is what's the actuarial, this is the care they're going to need the rest of their life. So the last piece of the puzzle is we'll go to an actuarial scale and go, what's the typical age the person's going to live? Now that's not a physician function. You shouldn't be doing that. The other ones are. So that's an attorney function. And you should be telling your attorney this too, because you don't want to look like the money grubber. You want the attorney to look like the money grubber, not the doctor. You want the doctor to just be about healthcare. You don't want a doctor talking about injury awards. So, but it's okay to go, this was the therapy that was needed. This was the cost and the frequency of therapy. That's a doctor function. An actuarial scale is not. So that's the attorney function. And then he just takes all that information, multiplies it out, and then multiply. That gives the prognosis and need of future care with a multiplier. And that's how that's supported. It's based on facts, not an opinion. And so there you are. There's how you support the typical personal injury case. Very important, unbelievably. It's actually way more important than the attorneys to even know. How little they know about how much they're missing is unbelievable. And we say that all the time. Out of the 10 major categories of documentation that I've identified that will determine the injury award, the average doctor misses 7 out of 10. They don't even document 7 out of 10 categories, or 57% of all the diagnostics. They don't even do it. I'll throw out a diagnostic test, and I can't tell you how many times the doctor will say, "What's that?" They don't even know of the test that validates this injury. Okay. All right, so that's how you become unbelievably valuable. You're a chiropractor. When you actually know this information, you are just tremendously valuable, which leads to the next problem. How do you get them to see your value when they don't have a perceived need for you? Well, that's where educational sales comes in. Publicity won't do it. Advertising won't do it. That's when you have to have another skill. You now have to have the knowledge and skill to be able to shift somebody's unconscious awareness to conscious incompetence. That's a skill set. I mean, once you know anything, it's easy, but you actually have to learn it. And of course, when you do, that's when you unlock this massive personal injury market that the vast majority of people, remember, are not even going to chiropractors. Remember, 2/3 of them don't even go to chiropractors, but 87% of them have a soft tissue injury. You don't even have to take any patients from anybody. There's this massive market out there. And 75% of the attorneys don't even use chiropractors. There you go. And we know why. It's bad documentation. Chiropractors don't know the documentation to do what we just showed, which was to support the categories of the injury award. And that's where the value is at. That's what when you not only know how to do it, you know how to communicate it. That's where you create a lot of business. That's when you become invaluable. And especially when you get to, can you explain it in a deposition or trial testimony? Now, 95% of the cases will not go to trial. 95. But you always want to document as if it's going to trial and prepare if it's going to trial. That's how you want to handle every case. And then you want to be able to show the attorney, Here's the line of questioning. Here's the categories of questioning. And the line of questioning that I want, that I need you to ask me these questions so I can sequentially and logically piece this whole case together, where it comes out at the end and it's overwhelmingly strong and makes sense. These are the questions. There's a little over 100 questions and multiple very specific categories that need to be addressed. That's what we're going to be covering specifically, and how to do the deposition and trial testimony. And by the way, that's another opportunity to educate the attorneys. They don't know how much they don't know relative to how to give a deposition or trial testimony, because they don't know medicine. They're not healthcare providers. And the most of the deposition trial testimony putting together is about healthcare, not law. That's why. Again, another opportunity, if you know it.